check what page I was on. Okay. Um, Another update. I swear. Another update. Or the first one didn't process properly and it hung me up. I went into check updates and it said that I had a restart coming, and I've already restarted twice. So, whatever. And then it froze my microphone up, which is why I had to bomb out this last time, because I couldn't get that working. But looks like we are in business. I had us at page 61, and I'm gonna start at this last paragraph of set one. So I think that's pretty much where we were at. I also blew out the computer with air, and I've got the box open, and with that and the air conditioning going, I shouldn't have an overheating problem. So I think the only thing we have to worry about now is my voice, and it feels real good right now. So let me take a quick sip of tea. So I think we're going to be good. Also, I grabbed something to eat, so I'm good to go. All right, we're going to start right here. However, Rybicki said he did not recall Comey being troubled by the meeting or expressing concern that the instruction from Lynch was an effort to coordinate with the Clinton campaign. And in case you missed that earlier, the instruction from Lynch was to call it a matter, not an investigation. And so here's a joke regarding that. Rybicki also said that he personally did not come away from the meeting with the view that Lynch was biased. Rybicki did recall Tosca joking about the Federal Bureau of Matters, which I think is hilarious, and I'm going to use as often as I can from now on. Lynch's recollection of the meeting. Lynch told the OIG that Comey expressed concern during the meeting about how to comply with the department's long-standing policy of neither confirming nor denying ongoing criminal investigations in the face of direct questions about the number of agents assigned to the case and the resources dedicated to it, because answering those questions implicitly would acknowledge that there was an open investigation. Lynch said that providing testimony about the allocation of resources or the way that the department works a case is a normal practice, but that in her view, they were not ready to publicly confirm an investigation. Lynch stated that her discussion with Comey was framed in terms of how they could testify about the resources dedicated to the investigation without breaking department policy. Lynch said that Comey was seeking guidance on how to handle those issues, particularly given that the referral was public and that detailed information about the investigation had been discussed in the press. Lynch said that she was aware of numerous letters from members of Congress requesting information about the investigation, and that her meeting with Comey took place around the same time as a telephone call she had with Senator Charles Grassley, who wanted to discuss the department's handling of Brian Pagliano, a State Department employee who set up one of Clinton's servers, in order to inform Congress's decision as to whether to grant him immunity or compel his testimony before Congress. And you may recall that he did not get pushed, nor did he show up for his testimony. So he skated, absolutely skated. Lynch told the OIG, Senator Grassley was asking me literally, will I confirm that there is a criminal investigation of Secretary Clinton? Who are the other targets? Who are the subjects? Has a grand jury been impaneled? Has this young man, Pagliano, been given immunity? Would I give him a copy of the immunity order and all things that the Oversight Committee typically asks for? So I knew, and I certainly had the view, that we had to be clear and open with oversight, whether it's me or the director. But consistent with our law enforcement obligations, there are some doors that we do not open, and I did not think that we were ready to open that door on the Hill at that time. Lynch said that her concerns about opening the door to detailed questions about the investigation informed her view that the department should not confirm that there was an investigation. She said that she recalled stating at the meeting with Comey, they don't need us to tell them that there is an investigation. They need us to confirm that there is an investigation, and there is a difference. She explained. And once we confirm it publicly, either by saying yes, there is an investigation, or by talking about it in a way that confirms it, the next series of questions is going to be, is it criminal? And it's all going to be about, is the secretary a subject or a target? And there were many others involved as well. Yeah. There are other people beyond her who may or may not be named out, but, you start having these discussions. When will it ever be over? What are you finding? All those things that, in fact, Grassley did ask. The OIG asked Lynch if she instructed or told Comey, quote, I want you to call it a matter, unquote. Lynch said that she did not and would not have because that was not how she spoke to people. She told the OIG that she remembered saying the following at the meeting. Well, I do remember saying, we typically say we have enough resources to handle the matter. I don't know if I used other words like the case, the inquiry or something like that. But I do remember saying that, and I think I may have been saying that because, again, I was always careful not to talk about an investigation. I was getting questioned about the referral, and is it going to lead to an investigation? And, we have it, we acknowledge it, we're going to handle it, and that's all I can say kind of thing. And so I know that in addition to saying, yes, everyone knows there's an investigation, they don't need us to tell them that, they need us to confirm it, and we don't do that. And here's why we don't do that. I remember making those statements, and I remember saying, but of course you've got to respond. And one way to respond is just to say, you've got what you need to handle the matter. Okay, so she called it a matter. She's admitting to calling it a matter. And it's just a small step to go from her saying, do we have what you need to handle the matter, to saying, call it a matter. And I'll leave it up to you to decide if she crossed that line or not. Personally, I'm pretty sure she did. I know Comey isn't a very reliable witness. In fact, he's a pretty unreliable witness. But he's been saying this from the start. Is he covering his butt, or did Lynch tell him to do that? I'm thinking she did it. But again, that's my opinion. Lynch said that she thought that there had been an agreement at the meeting about what to say. Her takeaway was that they were going to take steps not to confirm that there was an official investigation open, and we would be careful not to do so in how they discussed it. Lynch stated, it wasn't a long meeting, it was that it wasn't contentious, nobody seemed upset, so it was more of a discussion. She said that she did not recall Comey or anyone else expressing disagreement, or Comey asking, why on earth would I do that? I do not recall, Senator. Lynch said that the decision to avoid confirming an investigation was not made with any political motive in mind, and that she did not coordinate messaging with the Clinton campaign. Lynch told the OIG that she was surprised to learn from Comey's later congressional testimony that he interpreted the discussion at the meeting as evidence of potential political bias. She stated, "I was surprised. I was disappointed, somewhat angry, and mostly surprised that he had never raised it, either at the time or later, that if it was a concern, I was surprised that if he thought that it was a problem, he was okay also handling things in that way. I just had never viewed him as someone who was reluctant to raise issues or concerns, given that I had known him for some time." Lynch recalled Tuskus making a joke about the Federal Bureau of Matters to one of the agents who was sitting beside him and people laughing. She said that she took this as a joke, a good-natured ribbing or teasing, and that the laughter told her that others in attendance also took it as a joke. Yeah, but it was a joke based on fact, Lynch. Axelrod told us that the discussion about whether to acknowledge an investigation was just one small part of that meeting. He said that Lynch suggested using the term matter as a way of, quote, threading the needle, unquote, to avoid violating department policy while also not appearing evasive. According to Axelrod, no one from the FBI raised objections during the meeting, and the tone of the discussion was collegial. He said that he thought that Comey and Lynch had reached a, quote, mutual agreement that using the term matter was the best way to thread the needle, unquote. So she did say to call it a matter. Maybe Comey didn't say, why on the earth would I do that? Maybe not. But it's right there. That's what was said. You've got Tuskus and now Axelrod saying that that's what happened. Axelrod told the OIG that he was surprised to hear Comey's later congressional testimony that he, Comey, felt uncomfortable with the discussion, which Axelrod said was not consistent with his recollection of Comey's reaction in the room. It did not square with his recollection of the facts. Again, Comey could be lying and telling the truth within the same sentence. Tuskus notes and recollection of the meeting. Tuskus took I said Tuskus earlier. It was not who I should have said. There was someone else before Axelrod. My apologies. Tuskus took detailed notes at the September 28 meeting, which he provided to the OIG. Tuskus said that his notes were unusually lengthy for such a brief meeting because AAG Carlin was out of town and he was asked to attend in Carlin's place, and he wanted to be able to tell Carlin what happened. Referencing his notes, Tuskus testified to the OIG at length about what took place during the meeting. According to Tuskus, Comey told Lynch that he planned to acknowledge at a House Permanent Select Committee on Intelligence roundtable that the FBI had received the referral from the ICIG and that it was being properly staffed and receiving all necessary resources. Comey stated that he planned to say that the FBI does not comment on its investigations per long-standing policy, but that all of its investigations are done professionally and timely. Tuskus said that Comey assured Lynch that he would not say that they had opened an investigation, but that this would be implicit in what he said, and there would be news reports afterwards saying that there was an investigation. According to Tuskus, Lynch replied, I do apologize, that she preferred to discuss it in terms of a matter. It's two people plus Comey now. This is the way I do it, and then it avoids the issue because we should neither confirm nor deny. Tuskus said that he interpreted Lynch's statement as expressing her preference expressing her preference rather than telling Comey what he should do. Tuskus stated he did not recall Lynch instructing Comey to call it a matter, and he thought he would have remembered that if it had occurred. He also said that he did not interpret Lynch's comments as her trying to shade the investigation into something it wasn't for some particular reason, quote unquote. However, he acknowledged that he was not the FBI director and that Comey may have had a different perspective. Tuskus said that after Lynch's comment, Axelrod stated that they needed to coordinate what to say with a letter sent by the FBI General Counsel to State Department the previous week and attached to a public filing in FOIA litigation in which the FBI, quote, took great pains not to call this an investigation so as not to confirm the existence of an investigation, quote, end quote. They keep confirming it. According to Tuskus, the department and the FBI had used the same language in other letters to Congress, and Lynch had a call scheduled later that day with Senator Charles Grassley in which she planned to tell him that it would be premature to acknowledge or share information about any investigation. Tosca said that Axelrod's statement led to a back and forth between Comey and Axelrod, during which Comey proposed modifying the letters to Congress to acknowledge that the FBI had opened an investigation. Tosca said he was not sure if Comey was toying with Axelrod at that point, because I don't think we would ever reissue letters that clearly state normal positions. Tosca said that Comey then asked Axelrod directly, why not use the word? You know, we're trying to treat it like any other case, and we would do that ordinarily. In response, Axelrod again mentioned the need to be consistent with the letters that were sent the previous week. Tosca told the OIG that he mentioned at the meeting that the department opens only a small fraction of the referrals it receives from the intelligence community as criminal investigations, and that the department may not want to publicly acknowledge an investigation into former Secretary Clinton because it could serve as a precedent for other referrals. Tosca said he also made clear to the group that Midyear was a criminal investigation and that prosecutors had referred to it as an investigation in letters to counsel and in search warrant applications. Tosca said that Comey concluded the meeting by agreeing to call it a matter, stating, okay, I think that will work. This statement also appeared in Tosca's contemporaneous notes. Tosca told the OIG that there was no indication at the time that Comey was concerned about the meeting or that the meeting had led him to question Lynch's impartiality. Turn this down a little bit. Asked whether he made a comment to Comey about the Federal Bureau of Matters, Tosca said he did not specifically recall doing so, but may have. He said that if he did, he intended it as a joke rather than a criticism of Lynch. He told the OIG, I don't know if I ribbed Comey walking out. You know, he's a friend of mine. In any event, maybe I said that, maybe I didn't. It wouldn't faze me if I did, because it was in line with what I was saying to them about investigation being part of FBI's name. But it makes it appear as though I was sort of knocking the AG, Lynch, in the way they reported it, which is obviously why some goofball felt that they should talk about that to the newspapers. October 1st, 2015, Comey meeting with the media. In a quote-unquote pen and pad with reporters on October 1st, 2015, Comey used the term matter in response to questions about whether the FBI had opened an investigation. According to a transcript of the appearance, Comey told reporters that he recently had closed session with HPSCI and would say publicly what he told the committee, that the FBI had received a referral involving former Secretary Clinton's use of a private email account and that the possible exposure of classified information through that account, but that he was limited in what he could say because the FBI does not talk about its ongoing work. Comey stated, quote, I am following this very closely and I get briefed on it regularly. I am confident that we have the resources and the personnel assigned to the matter as we do all our work, so we're able to do it as we do all our work in a professional, prompt, and independent way, unquote. Asked about the timeline for completing any investigation, Comey stated, again quoting, again, I'm not going to talk about this particular matter. Part of doing our work well is that we don't talk about it while we do it. Following Comey's appearance, various news articles reported that Comey had acknowledged the existence of an investigation into former Secretary Clinton's use of a private email server. Comey received an email containing news clips summarizing several of these articles and forwarded it to Rybicki, stating, I looked off screen, stating, we'll leave it to you to tell DOJ that I never used the word investigation. Rybicki replied, already covered. I read back your statement to them and told them this is exactly the type of confusion we were concerned about as we were crafting. Reaction to White House statements about the Midyear investigation. On Sunday, October 11th, 2015, an interview of then-President Barack Obama was aired on the CBS show 60 Minutes. During this interview, Obama characterized former Secretary Clinton's use of a private email server as a, quote, mistake, unquote, but stated that it did not, quote, pose a national security problem, unquote, and, quote, and was not a situation in which America's national security was endangered, unquote. Obama also stated that the issue had been ginned up because of the presidential race. 2 days later, on October 13th, 2015, Obama's press secretary, John Earnest, was asked whether Obama's comments, quote, should be read as an attempt to steer the direction of the FBI investigation, unquote. Ernest replied that Obama had made his comments based on public information and that they were not intended to influence an independent investigation. Of course not. Former President Obama's comments caused concern among FBI officials about the potential impact on the investigation. Former EAD John Giacolone told the United States that this is just a mistake. That's a problem, right? Former AD Randy Coleman expressed the same concern, stating, the FBI had a group of guys in here, professionals, that are conducting an investigation, and the President of the United States just came out and said there's no there there. Coleman said that he would have expected someone in FBI or department leadership to contact one of Obama's national security officials and, quote, tell him or her, hey, knock it off, unquote. Michael Steinbach, the former EAD for the National Security Branch, told the OIG that the comments generated, quote-unquote, controversy within the FBI. Steinbach stated, quote, you're prejudging the results of an investigation before they really have been started. That's hugely hugely problematic for us. Department prosecutors were also concerned. Responding to an email from Loftman about Obama's 60 Minutes interview, Tosca stated, saw this, and as one of the prosecutors and I discussed last week, of course it had no, and will never have any, effect whatsoever on our work and our independent judgment. Prosecutor Ford told the OIG that Obama's statement was the genesis of the FBI's suspicions that the department's leadership was politically biased. This prosecutor stated, quote, This prosecutor stated, I know that the FBI considered those statements inappropriate and that it generated a suspicion that there was a political bias going on from the executive branch. Asked about former President Obama's statements, Lynch stated, I never spoke to the president directly about it because I never spoke to him about any case or investigation. He didn't speak to me about it either. She told the OIG that she did not think the president should have made the comment on 60 Minutes. She stated, I don't know where it came from, and I don't know. I don't know why he would have thought that either, to be honest with you, because to me, anyone looking at this case would have seen a national security component to it. So I truly do not know where he got that from. Former President Obama's press secretary, John Earnest, made additional comments about the Midyear investigation during a press conference in early 2016. On January 29, 2016, in response to a question about whether the White House thought that former Secretary Clinton would be indicted, Earnest stated, that will be a decision that is made by the Department of Justice and prosecutors over there. Well, James Comey saw to it that it wasn't. What I know is that some officials over there have said is that she is not a target of the investigation. So that does not seem to be the direction that it's trending, but I'm certainly not going to weigh in on a decision or in that process in any way. That is, a decision to be made solely by independent prosecutors. But again, based on what we know from the Department of Justice, it does not seem to be headed in that direction. At this press conference, Melody Newman, the director of the department's Office of Public Affairs, received a transcript of Ernest's statements about the investigation and forwarded it to Axelrod and 3 other department officials. Newman stated in the email to these officials, I have spoken to the White House and asked that they clarify this to make clear that they have no insight into this investigation. And if they don't correct it, I will. I'm waiting to hear back. This email was also forwarded to Lynch. Asked about this email, Newman said that she spoke to Ernest that day. Newman said that Ernest told her that he had based his comments on what he had read in news stories, not conversations with anyone in the department. She said that no one in the White House had ever reached out to her about the Midyear investigation, nor was she aware of the White House staff reaching out to anyone else in the department, noting they were very careful about engaging us on that topic. Axelrod similarly told the OIG that Ernest's comments implied that the White House had received a briefing on the Midyear investigation, which he said, quote-unquote, never happened. Lynch's chief of staff stated that department officials were, quote-unquote, very upset about Ernest's statements because, as far as we knew, no one at Department of Justice had spoken to anyone in the White House about it, unquote. The chief of staff told the OIG that they were particularly concerned by Ernest's statement, that former Secretary Clinton was not a target. The chief of staff said that she spoke to officials in the White House counsel's office to tell them that the department did not know where Ernest was getting his information and to ask them to talk to Ernest. I'm going to scoot forward a little bit so I stop shouting. Okay, I'll check my levels. All right, that's good. The Chief of Staff said that she spoke to officials in the White House counsel's office to tell them that the department did not know where Ernest was getting information and to ask them to talk to Ernest. The Chief of Staff did not specifically recall Lynch's reaction to the statement, but said that she was, quote, probably very upset anytime there was ever any suggestion that the White House or that the DOJ had improperly done something in an investigation or discussed something of a political nature. She would not be happy about it, unquote. Prosecutors again were concerned by these comments. On January 29, 2016, Tosca sent the following email to Loughman seeking to assure the team that the investigation would not be influenced by the White House statements. As discussed, I spoke with ODAG and they are not aware of anybody from DOJ sharing any such information or assessment with the White House. I'm sorry, Ray. I missed that. I missed your comment earlier. First, I don't get the context. Does that mean you were the first one here and the last one to leave? I can't quite. It's a little cryptic for me. Go ahead and put something else in there, and I'll pick it up. I want to reiterate what I've told you and the team throughout our work on this investigation. The explicit direction we received from the AG and DAG on multiple occasions is that they have total confidence in the team of prosecutors who are working on this case, and they have instructed us to proceed with this matter as we would any other, without interference of any kind, and with the independence we have in all of our cases. They have never wavered from that, and have never said or done anything to send or suggest a contrary message. With respect to the below statements that erroneously imply that the department has shared information about or an assessment of this matter with the White House, we should not and will not allow such irresponsible statements to have any effect at all on our work. We will continue to thoroughly and professionally investigate this matter as we would any other, and as always, and as you, John Carlin, and I have said repeatedly, we will follow the facts wherever they lead. Thanks. Toscas emailed Loughman a second time stating, please feel free to share this with the whole team if you haven't already. During his interview with the OIG, Toscas described Ernest's statements as goofy and ridiculous, expressing frustration that he had to address comments by the White House when preparing Lynch to testify before Congress because of the perception of political bias that they created. Asked about Ernest's statements, prosecutors told the OIG that the only interactions they had had with the White House concerning the investigation were with the White House counsel's office to obtain a classification review of documents in a special access program controlled by the White House and to interview a National Security Council staffer. Prosecutor 1 told the OIG that he was not aware of contacts between the department leadership and the White House counsel's office or White House staff. Notes taken by Loughman indicate that on January 30th, 2016, one of the prosecutors reached out to their point of contact in the White House counsel's office and asked about Ernest's comments. According to these notes, this prosecutor was told that the content of the discussions between the White House counsel's office and the Midyear team about the classification review and the interviewer of the staff was limited to a small group of people in the White House counsel's office, and that nothing that the prosecutors had discussed with the White House counsel's office would be known to Ernest. Lynch testified before the Senate Judiciary Committee on March 9, 2016. Asked about the investigation, Lynch stated that she had never discussed the investigation with former President Obama or anyone in the White House. Lynch stated, "It's my hope that when it comes to ongoing investigations that we all would stay silent. And I can assure you that neither I nor anyone from the department has briefed to Mr. Ernest or anyone at the White House about this matter or any other law enforcement matters. I'm simply not aware of the source of his information." Lynch told the OIG that she recalled that Newman spoke with the White House Communications Office after Ernest's comments and was clear that they were inappropriate and needed to be corrected. Asked whether she perceived these comments as an effort to direct where the investigation was going or felt influenced by them, she said that she did not. Lynch said that she also had a discussion with the White House counsel after she testified, and that during this discussion he acknowledged that the comments should not have happened. But were they ever corrected? However, former President Obama again made public comments about the mid-year investigation in an interview with Fox News Sunday on April 10, 2016. Obama stated that while former Secretary Clinton had been, quote-unquote, careless in managing her emails while she was Secretary of State, she would never intentionally do anything to endanger the security of the United States with her emails. Careless, that's exactly the word that the declination letter used when Comey read it out on July 5th regarding the dropping of the case against Hillary. Exactly the word. But again, no influence whatsoever. He also stated that he would not interfere in the FBI's investigation into her private email server. Obama stated, "I guarantee that there is no political influence in any investigation conducted by the Justice Department or the FBI, not just in this case, but in any case." Of course, let's not talk about the IRS throttling Republican 501c3s during the 2012 campaign. That didn't happen. Chapter 5, Investigative Methods Used in the Investigation. All right, I'm going to skip that preamble. FBI efforts to identify and review relevant sources of evidence. The mid-year team began its investigation by reviewing the 30,490 emails that Clinton had produced to the State Department. They reviewed them to identify emails that appeared to contain classified information and evidence of intent to mishandle classified information. Witnesses told us that to search for evidence of intent, the analysts looked for, among other things, classification markings on the documents, statements including that the email participants knew the information was classified, and statements indicating that Clinton decided to use a private server for an improper purpose, such as to avoid FOIA or other laws. Oh, no, that wasn't the case at all. One analyst told us that there were at least 6 analysts consistently involved with reviewing these emails, and at times there were as many as 15 or 16 analysts doing so. Wow. Once the team identified emails that appeared to contain classified information, they sent them to other agencies within the U.S. intelligence community with equities in them for formal classification review. FBI agents and department prosecutors told us that thereafter, a large focus of the investigations was locating the remaining 31,830 emails that made up the entire 62,320 that Clinton attorneys had reportedly reviewed before producing her work-related emails to the State Department. Well, good luck there, because they bleach-bit her mail servers. Clinton's attorneys did not produce those 31,830 emails to the State Department because, they stated, they were personal in nature. Instead, the attorneys instructed Paul Combetta of Platte River Networks, the company that managed Clinton's servers, to remove the emails from their own laptops and modify the server's email retention period so that emails older than 60 days would not be retained. Again, completely in violation of the Records Retention Act. In March 2015, Combetta removed the emails from Clinton's server using BleachBit after realizing he had failed to implement the new emails retention period several months earlier. The FBI team wanted to review these emails if possible to determine whether any were work-related or contained classified information and to search for evidence of Clinton's intent in using a private server. Remember, you don't have to prove intent. That's not part of the statute. FBI agents and analysts, including the supervisory special agent assigned to the mid-year investigation, told us that to find the missing 31,830 emails, the team attempted to identify and obtain access to any server or device, quote, whether it was a BlackBerry, iPad, PC, or phone, unquote, Clinton used during her tenure, as well as devices used to back up her emails. The FBI also sought email content or header information from the official U.S. government and private email accounts of certain individuals who were known to communicate directly with Clinton by email or who were involved in email chains that ultimately resulted in classified information being forwarded to Clinton. However, as discussed in Section 5C of this chapter, the FBI did not seek to obtain the personal devices of State Department employees besides Clinton, who sometimes used private email for State Department work and who used those devices to communicate with Clinton while she was Secretary of State. And I believe they stated earlier they didn't want to create an incredibly wide dragnet that would have made the investigation last for years, but I think they could have limited the scope to some of her top people and been good about it, or been good with it. Based on our review, the FBI sent preservation requests to the State Department for nearly 1,000 official State Department email accounts. One analyst told us that the State Department was unable to supply many of the email records the FBI requested due to, among other things, limitations in the State Department's record-keeping systems. However, the FBI obtained records from the official State Department email accounts of certain employees, including the 3 senior aides with whom Clinton had the most email contact. Well, there you go. All right, I back off. The FBI also made requests of other government agencies, including the CIA, the Defense Intelligence Agency, the Department of Defense, and the Executive Office of the President to search their official email systems for emails to or from email accounts on the clintonemail.com domain. In addition, as discussed in sections 3 and 5 below, the Midyear team used compulsory process to obtain email records from certain private email accounts. The FBI also requested the State Department issued computers and handheld devices used by certain employees during their State Department tenure. However, with the exception of a desktop computer used by Brian Pagliano, a State Department employee who set up Clinton's second server and who never testified, the State Department told the FBI that it either did not preserve or could not locate these devices. I think you heard the rumors of these devices being having their SIM cards ripped out and then bashed into little pieces with hammers. Can't prove it, but we have heard those accounts. So that could explain why they weren't able to get those devices. FBI witnesses told us that both FBI agents and analysts were involved in determining what devices and other evidence to obtain. Based on our review of the evidence, the FBI obtained more than 30 devices, received consent to search Clinton-related communications on most of these devices, only most, and identified numerous work-related emails that were not part of the 30,490 emails produced by Clinton's attorneys to the State Department, many of which they sent to other agencies for classification review. The 30 devices included 2 of Clinton's servers, each of which consisted of multiple devices, storage devices used alongside Clinton's servers, numerous devices that were used to back up Clinton's emails during her tenure, some of Clinton's handheld devices, Pagliano's State Department desktop computer, several flash drives and laptop computers that contained copies of the nearly 31,000 emails that Clinton attorneys used produced to the State Department, and the 2 laptops used by Clinton's attorneys to cull her emails for production to the State Department. Of course, all those emails were gone by the time they produced them. Once the FBI received consent to review a device, staff from the FBI's Operational Technology Division generally imaged the device and prepared the image for a filter team to remove material that was privileged or otherwise not subject to search pursuant to the terms of a consent agreement. OTD then uploaded the emails and other data from the device for FBI analysts to review. OTD also attempted to deduplicate emails. The analysts reviewed the emails recovered from each device for the same purposes as they reviewed the initial nearly 31,000 to identify both suspected classified information and evidence of intent to mishandle classified information. Again, intent is not necessary. The Midyear team also sought and obtained a wider range of other information relevant to the investigation, such as Clinton's cable, telephone, and internet subscriber and service information. Wow. Financial information for certain witnesses, business records pertaining to the services provided by the companies that supported Clinton servers, records related to security services protecting Clinton servers, and information from mail carriers related to the delivery of a laptop that at one time stored Clinton's archived emails. Prosecutor 1 told us that the team sought records from at least 3 different companies in an effort to find the BlackBerry emails from the beginning of Clinton's tenure as Secretary of State. Analysts told us that they reviewed these materials to search for, among other things, evidence of mishandling classified information and additional leads for information. For example, one analyst stated that through records obtained from various phone companies, he was able to identify the 13 devices that were associated with 2 telephone numbers that Clinton used. 13. According to the LHM, the FBI found and reviewed approximately 17,448 unique work-related and personal emails from Clinton's tenure, containing her email address that were not part of the original nearly 31,000 that Clinton's lawyers had produced to the State Department. Comey stated in his July 5, 2016 press conference that the FBI found, quote, several thousand, unquote, work-related emails that were not part of the nearly 31,000 emails. However, one analyst told us, and documentation we reviewed showed, that the FBI did not conduct its review in such a way that it could calculate the precise amount of work-related emails discovered by the FBI that had not been produced to the State Department. Instead, as described below, they focused on identifying the number of classified emails that both were and were not included in the nearly 31,000. None of the emails, including those that were found to contain classified information, included a header or footer with classification markings. As we discuss further in Chapter 7, this absence of clear classification markings played a significant role in the decision by the Midyear prosecutors to recommend to Attorney General Lynch in July 2016 that the investigation should be closed without prosecution. According to the LHM, the FBI, with the assistance of other USIC agencies, identified 81 email chains containing approximately 193 individual emails that were classified from the confidential to top secret levels at the time the emails were drafted on unclassified systems and sent to or from Clinton's personal server. In other words, the USIC agencies determined that these 81 email chains, although not marked classified, contained information classified at the time the emails were sent and should have been so marked. 12 of the 81 classified email chains were not among the nearly 31,000 that Clinton lawyers had produced to the State Department, and these were all classified at the secret or confidential levels. 7 of the 81 email chains contained information associated with a special access program which witnesses told us is considered particularly sensitive. The emails containing top secret and SAP information were included in the nearly 31,000 provided to the State Department. In June 2016, near the end of the investigation, investigators found 3 email chains consisting of 8 individual emails that, quote, contained at least one paragraph marked C, a marking ostensibly indicating the presence of information classified at the confidential level, unquote. According to a June 13, 2016 text message exchanged between Strzok and Page, the emails containing the C portion markings were part of the nearly 31,000 that Clinton's attorneys had provided to the State Department in 2014, but the FBI did not notice them until June 2016 after the ICIG discovered them. By that point in time, as discussed in Chapter 6 below, Comey had been drafting his statement announcing the closing of the investigation. Strzok wrote to Page that, quote, DOJ was very concerned about this because they've worried, holy cow, if the FBI missed this, what else was missed, unquote. Strzok further wrote, no one noticed, and while minor, it cuts against I never send nor receive anything marked classified. According to the prosecutors, Mills, Abedin, and Jake Sullivan were each parties to at least one email in the chain with the C markings. However, none of them were ever asked about the emails because the FBI had not discovered the markings before their interviews and did not seek to re-interview them. Witnesses told us that although the FBI found work-related emails, including classified emails that were not part of the nearly 31,000 produced to the State Department by Clinton's lawyers, they were not able to determine whether these emails were part of the over 62,000 reviewed by Clinton's attorneys. This is because some of the emails found through other sources could have been deleted from Clinton's account or, quote, overwritten in the ordinary course, quote, end quote, before Clinton's attorneys reviewed her emails for production to the State Department. Thus, they were also unable to determine how many of the nearly 32,000 deleted emails were never recovered. The FBI also conducted, quote, intrusion analyses, quote, on each of the devices and other evidence to determine whether any classified information had been compromised. An FBI agent assigned to the Midyear team to conduct intrusion and other forensics agent, described the team's efforts in this regard as exhaustive. He stated that these efforts included 1. Examining the servers and other devices to identify suspicious logins or other activity, and 2. Searching numerous data sets to determine whether foreign adversaries or known hostile domestic actors had accessed the emails that the Midyear team had confirmed to contain classified information. And again, these are only the emails that were turned over. The 32,000 that they did not turn over, there's no way to determine if any of those had been improperly accessed or not. Comey stated the following in his July 5, 2016 press conference regarding possible cyber intrusion of Clinton's email servers. With respect to potential computer intrusion by hostile actors, we did not find direct evidence that Secretary Clinton's personal email domain, in its various configurations since 2009, was successfully hacked. But, given the nature of the system and of the actors potentially involved, we assess that we would be unlikely to see such direct evidence. We do assess that hostile actors gained access to the private commercial email accounts of people with whom Secretary Clinton was in regular contact from her personal account. We also assess that Secretary Clinton's use of a personal email domain was both known by a large number of people and readily apparent. She also used her personal email extensively while outside the United States, including sending and receiving work-related emails in the territory of sophisticated adversaries. Given that combination of factors, we assess that it's possible that hostile actors gained access to Secretary Clinton's personal email account. So there you go. Remember now, she would not use a State Department or intelligence approved phone. She wanted to use her BlackBerry because basically she knew how to use it, and she didn't want to learn how to use one of theirs. So there she is conducting sensitive work over a private email account that is easily hacked over a BlackBerry that everyone knows how to hack. The LHM stated, FBI investigation and forensic analysis did not find evidence confirming that Clinton's email server systems were compromised by cyber means. However, the LHM also stated that the FBI identified one successful compromise of an account belonging to one of former President Clinton's staffers on a different domain within the same server former Secretary Clinton used during her tenure. The FBI was unable to identify the individual responsible for the compromise, but confirmed that the individual had logged in to the former staffer's account and, quote, browsed email folders and attachments, unquote. According to evidence we reviewed, the FBI also confirmed compromises to email accounts belonging to certain individuals who communicated with Clinton by email, such as Jake Sullivan and Sidney Blumenthal, her hatchet man. The LHM stated that the FBI was limited in its intrusion analysis due to the FBI's inability to recover all server equipment and the lack of complete server data for the relevant time period. So again, those 32,000 emails that she didn't provide, no way to know how many of them were hacked. According to the LHM, the FBI also identified vulnerabilities in Clinton's server systems and found that there had been numerous unsuccessful attempts by potential malicious actors to exploit those vulnerabilities. Nonetheless, the FBI forensics agent told the OIG that although he did not believe there was any way of determining 100% whether Clinton servers had been compromised, he felt fairly confident there wasn't an intrusion. When asked whether a sophisticated foreign adversary was likely to able to cover its tracks, he stated, "They could, yeah, but I felt as if we coordinated with the right units at headquarters for those specific adversaries, and the information that was returned back to me was that there was no indication of a compromise." The Midyear team's efforts to understand and access Clinton's servers. This ought to be good. Prosecutor 1 told us that it took the Midyear team time to understand the setup and sequence of the various servers Clinton used. So see, it wasn't just that one server, she used several. This prosecutor stated that an understanding of the server setup was a necessary foundation for the Midyear team's investigation. According to the LHM, the FBI discovered 3 servers that for different periods stored work-related emails sent or received by Clinton during her tenure as Secretary of State. Collectively refer to these 3 servers as the Clinton servers, none of which were legal. The first server was set up in 2008 by Justin Cooper, a former aide to former President Clinton, and is referred to in the LHM as the Apple server. Based on evidence we reviewed, the Apple server was primarily set up for former President Clinton's staff, but Secretary Clinton also used it for her work purposes from January 2009 until approximately March 18, 2009, about 2 months into her tenure. During this time, Clinton primarily used a personally acquired BlackBerry device that was connected to the Apple server. The LHM indicates that the second server, referred to in the LHM as the Pagliano server, was used from March 2009 through June 2013. Cooper told the FBI that in or around January 2009, the decision was made to move to another server because the Apple server was antiquated and users were experiencing problems with email delivery on their BlackBerry devices. Again, none of those are legal. The State Department does not allow you to use BlackBerries. Cooper contacted Brian Pagliano, an information technology specialist who worked on Hillary Clinton's presidential campaign, to help him set up the Pagliano server. Numerous individuals had email accounts on the Pagliano server, including former President Clinton, former President Clinton's staff, Uma Abedin, who was Clinton's deputy chief of staff at the State Department, and Clinton herself. Clinton and Abedin were the only State Department employees with accounts on the clintonemail.com domain on the Pagliano server. The third server, which is referred to in the LHM as the PRN server, was active after Clinton's tenure as Secretary of State and as Secretary of State ended, from approximately June 2013 through October 2015. The LHM stated that in early 2013, staff for Clinton and former President Clinton discussed transitioning to a new vendor for email services, quote, due to user limitations and reliability concerns regarding the Pagliano server, unquote. The staff chose the Denver-based information technology firm Platte River Networks for this purpose. According to the LHM, PRN employee Paul Combetta migrated the email accounts from the Pagliano server to the PRN server. Following the migration, the Pagliano server was stored in a data center in New Jersey, although it no longer hosted email services, and Microsoft Exchange was uninstalled from it on December 3rd, 2013. Okay, here's another illegality. You can't take government work-related emails and put them on a cloud server, which is what Platte River is. It's a cloud server. That's, again, according to the LHM, the FBI learned through witness interviews that the Apple server in use from 2007 to March 2009 was ultimately discarded, and thus the FBI was never able to access it for review. However, based on evidence we reviewed, the Midyear team obtained access to certain backup data from the Apple server held on Cooper's personal laptops through consent agreements with Cooper's attorney. The Midyear team obtained both the Pagliano and PRN servers through consent agreements with David Kendall and Clinton's other attorneys at Williams and Connolly. The FBI's ability to review emails on both the Pagliano and PRN servers was limited. With respect to the Pagliano server, most of the emails that remained on it following the transition to the PRN server were in the unallocated space due to the removal of Microsoft Exchange in 2013. FBI analysts told us that emails in the unallocated space were often fragmented and difficult to reconstruct. I'm sure they did mean for that to happen. With respect to the PRN server, the FBI discovered through forensic analysis and witness interviews that Combetta had transferred most of Clinton's archived emails from her tenure as Secretary of State to the PRN server, but subsequently deleted and wiped them from the server using BitChute. Based on the LHM, FD302s, and PRN documents collected by the FBI, the transfer of emails to the PRN server and subsequent wiping of the PRN server occurred as described in the paragraphs below. At around the time of the transition to the PRN server in the spring of 2013, Clinton's former aide, Monica Hanley, recreated 2 archives of Clinton's emails from the Pagliano server, one on a thumb drive, archive thumb drive, and one on a laptop computer, archive laptop. In early 2014, Hanley mailed the archive laptop to Gambetta to transfer Clinton's archived emails to the PRN server. She further directed him to, quote-unquote, wipe the archive laptop and mail it to Clinton's office assistant at the Clinton Foundation after he completed the transfer. Gambetta used a quote-unquote dummy email account to transfer Clinton's archived emails into a mailbox entitled HRC Archive on the PRN server. Gambetta told the FBI that he then, per Hanley's instructions, deleted the emails from the archive laptop and mailed the archive laptop to Clinton's office assistant, but did not wipe the laptop. Email records obtained by the FBI showed that Clinton's office assistant sent emails to Gambetta in both March and April 2014 asking when she should expect to receive the wiped laptop. However, Clinton's office assistant told the FBI she did not recall ever receiving it. That's the famous "we lost it in the mail" laptop. Not wiped, sensitive information on it, and it was sent through unregistered mail. An analyst told us an FBI records show that the team sought and obtained records from multiple mail carriers in an effort to locate the archive laptop. Based on these records, the FBI was able to confirm that the laptop was delivered to Paul Gambetta on February 24, 2014. However, the FBI found no records showing that Gambetta mailed the archive laptop to Clinton's office assistant as requested. The FBI also attempted to obtain the archive thumb drive from Hanley, but she stated she could not recall what happened to it. Bleach-bitting 32,000 emails, losing a laptop with archived emails, and then losing a thumb drive with archived emails. Not suspicious in least. According to the LHM, FD302s from Gambetta's, Mills, and Samuelson's interviews and PRN documents collected by the FBI in the summer of 2014, Gambetta uploaded PST files of Clinton's archived emails to Mills and Samuelson's laptops to enable them to review Clinton's emails and produce her work-related emails to the State Department. In late 2014 or early 2015, after Clinton produced her work-related emails to the State Department, Mills and Samuelson requested that Gambetta remove Clinton's emails from their laptops, and he did so using BleachBit. At around the same time, Mills directed Gambetta to change the email retention policy on ClintonEmail.com account to 60 days because Clinton had decided she no longer needed access to her personal emails that were older than 60 days. Well, you weren't keeping the work-related ones either, were you? Gambetta told the FBI that he mistakenly neglected to make the change at the time and realized his mistake in March 2015. He stated that despite the intervening issuance of a congressional preservation order on March 3, 2015, he had an "oh shit" moment, quote-unquote, and wiped the HRC archive mailbox from the PRN server using BleachBit sometime between March 25th and March 31st, 2015. Again, not suspicious in the least. Despite the use of BleachBit, the FBI was able to recover some of Clinton's archived emails from both the PRN server and the laptops used by Mills and Samuelson to cull Clinton's emails. Let's hear it for the FBI. The FBI also recovered some of Clinton's archived emails from a search of the dummy email account that Gambetta used to transfer Clinton's emails from the archive laptop to the PRN server and, as discussed in Section 1 of this chapter, from various other sources. Section 3, use of criminal process to obtain documentary and digital evidence. Despite the public perception that the Midyear investigation did not use a grand jury and instead relied exclusively on consent, we found that agents and prosecutors did use grand jury subpoenas and other compulsory process to gain access to documentary and digital evidence. According to documents we reviewed, at least 56 grand jury subpoenas were issued, 5 court orders were obtained pursuant to 18 U.S.C. 273D, 270D3 orders, 2703D orders, and 3 search warrants were granted. The Midyear team also sent numerous preservation letters to various entities, including Internet service providers, former Secretary Clinton's attorneys, and U.S. government agencies. We were told that the FBI generally worked directly with the EDVA prosecutors to obtain subpoenas and 2703D orders without seeking approval from the CES prosecutors, Loffman, Toscas, or any higher-level department officials. Toscas told us that he was the highest-level department official that approved search warrant affidavits and that he provided general information about search warrants that were being sought in briefings to Carlin, Yates, and Lynch. The FBI served 2703D orders on commercial email service providers such as Google, Gmail, and Yahoo for information maintained on their servers associated with the private email accounts used by Uma Abedin, Paul Gambetta, Cheryl Mills, and 2 other individuals. The FBI sought 2703D orders for these individuals after discovering from other sources that emails containing classified information were sent from or received by their accounts. FBI witnesses told us that the purposes of obtaining the 2703D orders were to determine whether the known classified emails continued to reside in the unauthorized email accounts and whether they were forwarded to other unauthorized locations, thus posing risks to national security. If they confirmed that the known classified emails continued to reside in the email accounts, they would then consider seeking warrants for email content within the same accounts. Based on the 2703D results, the FBI was able to confirm that classified information continued to reside in just one of these 5 accounts, the account belonging to Gambetta. Thus, on June 20th, 2016, the FBI sought a search warrant for this account. According to the search warrant, the FBI initially sought the 2703D order for Gambetta's account after observing numerous emails containing metadata for Gambetta's dummy email account in the original nearly 31,000 emails provided to the State Department and determining that many of these emails contained classified information. Gambetta told the FBI that he created the dummy email account to transfer Clinton's archived emails from the archived laptop to the PRN server. Based on the results of the 2703D order, the FBI determined that 820 of Clinton's emails dated between October 25th, 2010 and December 31st, 2010 remained in the dummy email account. Wow. 5 weeks. The Midyear team obtained a search warrant to review the content of these emails and search for other emails relevant to the investigation. Prosecutor 2 told us that the Midyear team sought compulsory processes when evidence could not be obtained through consent or when, quote, the terms of the consent were such that additional processes needed to be sought, unquote. For example, on August 28, 2015, the Midyear team obtained a search warrant for the Pagliano server, even though Clinton's attorneys had voluntarily produced and provided consent for the FBI to search it. According to the search warrant application, upon conducting a preliminary investigation of the examination of the Pagliano server, the FBI discovered that it contained 3 domains, 2 besides the Clinton email domain, and email accounts of numerous individuals unrelated to the FBI's investigation, such as former President Clinton's staff. The FBI further discovered that Microsoft Exchange had been uninstalled from the Pagliano server in December 2013. Why? As a result, the 3 different domains were commingled in the server's unallocated space, and the FBI could not segregate the accounts without, quote, a complete forensic analysis of the Pagliano server, unquote. Because Clinton's attorneys were only able to provide consent to search Clinton's email accounts on the server, the FBI obtained a search warrant to examine the unallocated space. Section 4, use of consent to obtain physical evidence, Section A. Debate over the use of consent. Based on the evidence we reviewed, although the Midyear team used compulsory processes on multiple occasions as described above, the prosecutors sought to obtain digital and documentary evidence by consent whenever possible. Witnesses told us that this caused frustration within the FBI, which preferred obtaining evidence with search warrants or subpoenas. The witnesses generally agreed that this debate is common among prosecutors and agents and was not unique to Midyear. Then they're screwing up. To the extent the disagreement about the use of criminal process was more pronounced in Midyear, witnesses stated that they believed this was due to Midyear being a high-profile investigation. The lead analyst explained that, quote, everyone was under intense pressure, unquote, which enhanced the, quote-unquote, magnitude of the disagreement. Numerous department and FBI witnesses told us that the debate over how to obtain evidence was mostly about efficiency. The prosecutors believed they could obtain evidence faster through consent, and the FBI believed that criminal process was more efficient. The prosecutors stated that, in their view, consent is more efficient than process when witnesses are cooperative, and, as Prosecutor 4 noted, when there is no concern that evidence will be destroyed to obstruct an investigation. How naive. Based on the evidence we reviewed, Clinton's attorneys contacted department prosecutors numerous times to express Clinton's willingness to cooperate by being interviewed and providing evidence voluntarily after they deleted 32,000 emails. Prosecutor 4 told us it was his view that the risk of destruction of evidence in response to a voluntary production request is less likely in cases where parties are represented by experienced attorneys, such as firms like Williams and Connolly, which represented Clinton, because the attorneys are aware of the risk associated with destroying evidence. And I'm sure they've never performed any criminal acts in conjunction with the Clinton Foundation. Not a one. I know that's a broad statement, and it is, again, my opinion, but look who they're dealing with. Prosecutor 4 stated, I'm not saying that they're more ethical, I'm just saying that they're smarter. The prosecutors stated that seeking evidence through consent also saved time by allowing the government to avoid motions to quash subpoenas based on privilege or lack of probable cause. A few FBI witnesses told us that they believe the prosecutors in CES were generally more, quote-unquote, risk-averse in their handling of cases than prosecutors in other parts of the department. Prosecutor 1 explained that there are reasons to be especially cautious in the types of cases CES handles, including protecting the sensitive and classified information involved in those cases. The prosecutor told us that CES prosecutors must consider questions such as whether the intelligence community will permit the use of classified information in their cases, whether moving a case forward is worth the risk that the use of information gathered by a human source could identify sources and methods, and whether the criminal prosecution of someone is more valuable than the continued collection. Loffman and Prosecutor 4 told us that the use of criminal processes, I keep saying process. No, it is process. I get confused. I'm used to seeing it in the plural. I've said it both ways. I apologize. The use of criminal process tends to increase the risk of leaks in public disclosures. Prosecutor 4 told us that leaks undermine the investigations and that unfair leaks were an added consideration in the Midyear investigation. Loffman told us that the Midyear prosecution's team's goal was to make sure that no stone was left unturned, while also being mindful that leaks could be used by political actors in furtherance of political agendas. Agent 3 told us that when he sought process from the prosecutors, they responded that they would try to obtain the evidence by consent because the witnesses, quote, don't want this to get in the paper, unquote. Comey told us that he believed the prosecutors were more hesitant to use criminal process in the Midyear investigation than normal because they wanted to keep, quote, as low a profile as possible, unquote. FBI team members told us that they believed they could have obtained evidence faster with process, especially after instances where they believed Clinton's attorneys had not been forthcoming about the existence of potential sources of evidence. I thought they were smarter. For example, after Clinton's attorneys voluntarily provided the FBI the Pagliano server pursuant to an August 7, 2015 consent agreement, the FBI discovered through its own investigation that there was a successor server, the PRN server. According to documentation we reviewed, the prosecutors and the FBI were frustrated that Clinton's attorneys had not been forthcoming about the PRN server, and Prosecutor 1 wrote a letter to Kendall expressing this frustration. The SSA told us that situations like this caused him to question whether consent was the best course. However, Prosecutor 1 stated that resorting to compulsory process for the PRN server would have been complicated because, among other things, the server was, quote, running tons of people's email accounts on it and that were totally separate from the former secretary, including people working in the former president's office. The Midyear team ultimately secured the PRN server through a September 30th, 2015 consent agreement with Clinton's attorneys. Some witnesses told us they were concerned about certain devices that the FBI was never able to locate. I've referenced these before. For example, as described in Section 2 of this chapter, the Midyear team was never able to locate the archive laptop and archive thumb drive, both of which, according to Hanley and others, contained a complete copy of Clinton's archived emails. In addition to according to the LHM, the FBI's investigation identified a total of 13 mobile devices associated with Clinton's 2 known telephone numbers, quote, which potentially were used to send emails using Clinton's clintonemail.com email addresses, unquote. The Midyear team asked Clinton's attorneys for these devices, but they stated they were unable to locate them. According to the LHM and FD 302s, Cooper and Hanley told the FBI that they wiped or destroyed Clinton's devices once she transitioned to new devices. One FBI analyst told us that he was frustrated by the claim Clinton's attorneys that they could not find her 13 devices. However, he stated that he, quote-unquote, guessed the agency did not have probable cause to assert that the missing devices were in Clinton's home such that a search warrant could be issued, given the testimony that her old devices had been destroyed before she transitioned to new devices. He further stated that his frustration was with Clinton and her attorneys, not the prosecutors. We questioned whether the use of a subpoena or search warrant might have encouraged Clinton, her lawyers, Gambetta, or others to search harder for the missing devices, or ensured that they were being honest that they could not find them. Prosecutor 2 told us that the prosecutors believed that Clinton's attorneys were dealing with them in good faith and had no reason to think that they were lying about their inability to find Clinton's mobile devices. Prosecutor 2 further stated that the team did not believe that Gambetta still had the archived laptop in his possession because there would have been no reason for him to keep it. Of course not. He wanted to ditch it. Similarly, the lead analyst told us that he did not know of any evidence to suggest that Clinton's attorneys were being dishonest about the evidence they could not locate, and compulsory process would not have made a difference in situations where Clinton's attorneys represented that they could not find a device, well, because they'd been destroyed and thrown away. Agents 1 and 2 told us that there were 6 laptops that Clinton's attorneys had provided the FBI early in the investigation with consent to store, but not search, and that they would have liked to search these laptops. No, they didn't use compulsory process to get into those laptops. They were allowed to store them. What good is that? Agent 2 stated that he believed that these laptops may have been used to review Clinton's emails before Clinton's attorneys produced her work-related emails to the State Department. Agent 1 told us that he believed these laptops were used by Clinton's Williams and Connolly attorneys to do the, quote, QC of the 30,000 emails after they were called by Mills and Samuelson, unquote. A review of the relevant FD 302s and other documents revealed the following regarding the 6 laptops. On August 6, 2015, Catherine Turner, one of Clinton's attorneys, voluntarily produced to the FBI 3 thumb drives and a laptop computer belonging to Williams and Connolly that contained identical copies of the nearly 31,000 emails Clinton's attorneys had provided to the State Department and signed a consent form for the FBI to search these devices. In addition, Turner told the 2 FBI agents that Williams and Connolly had 6 additional laptops containing identical copies of the nearly 31,000 emails, but that these laptops also contained unrelated privileged information. Turner agreed to voluntarily produce the additional 6 laptops to the FBI so that the FBI could secure the classified information contained on them, but declined to provide consent to search the laptops because she, quote, wished to ensure that privileged communications on the laptops would remain confidential, unquote. According to an FD 302 dated on August 17, 2015, Turner told the FBI that one of the 6 laptops was in the custody of Mills and Samuelson's attorneys at Paul Weiss, Rifkin, Wharton, and Garrison LLP, known as Paul Weiss. On August 21st, 2015, FBI Attorney 1 wrote in a letter to Turner and Paul Weiss's attorney, "It is the FBI's understanding that the 6 laptop computers may contain privileged materials. Therefore, the FBI will maintain the 6 laptop computers in a secure location separate from other materials that have been provided voluntarily to the FBI in conjunction with this matter. The FBI will not access any material or information on the 6 laptops without further consultation with you or obtaining appropriate legal process. Upon completion of this matter, the FBI will notify all parties and discuss the appropriate disposition of the material in a manner consistent with applicable laws and policies." In other words, they just rolled over and played dead. Although the Midyear team left open the possibility of obtaining process to search the 6 laptops, the team ultimately never sought a search warrant. Prosecutor 2 explained that the Midyear team originally believed that the 6 laptops included the laptops that Mills and Samuelson used to call Clinton emails. However, during a proffer session on March 19, 2016, Beth Wilkinson, attorney for Mills and Samuelson, told the prosecutors that the 6 laptops Clinton's attorneys had produced to the FBI did not include the culling laptops, and, in fact, the culling laptops were still in Mills and Samuelson's possession. Prosecutor 2 told us that, following the proffer, Mills and Samuelson turned the actual culling laptops over to Wilkinson, who agreed to disconnect the laptops from the internet and place them in a safe in her office until privilege issues could be resolved. As described in Section 8D of this chapter, the Midyear team ultimately received consent to search the culling laptops through an agreement with Wilkinson. Agent 2 told us that, despite his desire to search the content of the 6 laptops, the FBI might not have had sufficient probable cause to assert that the laptops contained emails that the FBI did not already have in its possession. That's a valid point. I can see that argument. He further told us that it was completely logical, quote unquote, that Clinton's attorneys would not consent to the FBI's review of the laptops, given that the laptops contained privileged information related to the attorney's representation of other clients. Well, why couldn't they have, culled that information from the laptops and turned them over? I don't see. If they can bleach bit 32,000 emails off the server and off the laptops, surely they could cull the privileged content from other clients on those. I may be talking completely out of my ear. I don't know. It seems logical. Prosecutor 2 told us that, following the proffer, Mills and Samuelson turned the actual culling laptops over to Wilkinson, who agreed to disconnect the laptops from the internet and place them in a safe in her office. I'm sorry, I already read that. He further told us that it was completely logical that Clinton's attorneys would not consent to the FBI's review of the laptops. I already read that. FBI Attorney 1 told us that she believed, based on representations of Clinton's counsel, that the 6 laptops never contained the full nearly 63,000 emails and that they only contained copies of the nearly 31,000 emails that had been produced to the State Department. She stated that, as a result, she did not believe that it was necessary to review the 6 laptops, especially given the privilege concerns. Well, we addressed that. There were points in the investigation where the debate about the use of consent versus compulsory process was particularly pronounced. Based on the evidence we received in or about March 2016, Paige asked Strzok on behalf of McCabe to create a list of tasks that the department had either refused to undertake or, quote, asked to let them negotiate with counsel, unquote, even if the FBI ultimately agreed with the outcome. Paige told us that McCabe suggested the list after she told him that Strzok and FBI Attorney 1 were, quote, increasingly growing concerned about the little things that are being left on the cutting room floor and the deference to the, unquote, and the deference to, unquote, the line prosecutors on how best to obtain evidence. On March 24th, 2016, Strzok wrote to FBI Attorney 1 and the lead analyst describing the proposed list. In the email, Strzok provided a rough list of items he was considering, including, and wrote, "Problem is, it's been death by 1,000 cuts." Strzok told us that at the time he wrote this email, he was, quote, "aggravated by the limitations," unquote, that the prosecutors were placing on the FBI's ability to obtain evidence, and felt that, quote, "if you add up this delta over a bunch of decisions, all of a sudden it becomes substantive." And if you're not familiar with that term, delta means the change, the aggregate change from point A to point B. Strzok and Page told us that they did not believe a list was ever finalized. Despite this debate, the agents, analysts, prosecutors, and supervisors on the Midyear team generally told us that, aside from devices that had been destroyed or that could not be located, they ultimately obtained and reviewed all of the devices necessary to complete the investigation, minus 32,000 emails. For example, Strzok stated that once he was able to step back towards the end of the investigation, he realized that maybe we gave a little where we didn't need to give, and maybe we actually got lucky here. But is there anything that we ultimately are missing to make kind of an authoritative, accurate conclusion? No. McCabe stated that the team drew some red lines around things that we absolutely insisted we had to do, such as obtaining the laptops Mills and Samuelson used to call Clinton's emails, and that those items ultimately were obtained. The SSA, who was described to us by several witnesses as an experienced and aggressive agent, stated that he, quote, "had a lot of hoops to jump through at times, but no matter what the obstacles were, we moved through them," unquote. Similarly, Anderson told us that, quote, "at various times as the investigation progressed, we were very anxious to seek aggressively different materials, but at the end of the day, I do believe everybody felt that we had obtained everything that we needed to obtain in order to assess criminality." And again, you don't need intent. You just need the actual act to have occurred. Limit of consent agreements. The SSA told us that the terms of the consent agreements were primarily created through negotiations between the two-line NSD prosecutors on one side and the attorneys for Clinton and other witnesses on the other. For the most part, the consent agreements were limited such that the FBI was able to search for only 4 emails sent or received by Clinton during her tenure as Secretary of State and for evidence of intrusion. These were generally the same limitations that were included in the subpoenas, search warrants, and the 2703D orders obtained during the course of the investigation. An FBI analyst told us that limiting the search time period to Clinton's tenure as Secretary was not controversial. The analyst explained the reason it was scoped to the tenure is because, that is, of course, when she would have had access to the classified information. We questioned both Department and FBI witnesses as to whether emails from after Clinton's tenure could have shed light on whether Clinton instructed her staff to delete emails for an improper purpose. They told us that any relevant emails following Clinton's tenure mostly would consist of communications with her attorneys regarding the sort process, and such communications would be protected by attorney-client privileges. Okay, that was mostly would consist, not all. Again, why couldn't? The FBI has an office that is specifically designed to take email or laptops or whatever that may have client privilege information on them, and use a Chinese wall to screen that information and not allow it to move forward into the investigative process. Supposedly, that's what they're doing with Cohen's computers and phones and all that, supposedly. But they've been leaking a lot of information, so who's to say they wouldn't have done that with this? But again, it's possible. Just because there's client privilege information on there doesn't mean you can't search it for other things. The consent agreements and search warrants also were limited such that the FBI could not search emails sent or received by other account holders on Clinton servers, such as Abedin and former President Clinton and his staff, unless Clinton was also a party to those emails. One analyst told us that he would have liked to be able to look at emails to which Clinton was not a party. For example, he told us that he would have liked to review emails between Abedin and Cooper regarding what Clinton may have said about the server. We questioned the prosecutors as to why the consent agreements were not scoped such that they could search for any work-related or classified emails within the Aberdeen Clinton email account, so especially since the FBI witnesses told us that Clinton's server, not Clinton herself, was the subject of the investigation. This is addressed in Section 5D of this chapter below. The consent agreements and search warrants incorporated provisions requiring the use of a filter team to ensure that the Midyear team did not review emails protected by privileges, including attorney-client, medical, and marital privileges, which I just discussed. One analyst told us that the filter process was cumbersome and that some interpretations of the privileges were unusual. For example, because former President Clinton did not use email, one of his employees received former President Clinton's emails and then printed them for him. The privileged team considered the emails that Clinton sent to her husband through this employee as privileged, although this may not have been legally required. The lead analyst told us that he, too, was often frustrated by the cumbersome filter process. However, he stated that he agreed with the team's quote-unquote conservative approach to interpreting what was privileged because it was important for the FBI to handle its mission and the materials in its possession quote-unquote responsibly and to not unnecessarily be looking into, quote, into the lives of the Clintons. Well, the the investigative team looking at the Clinton Foundation is taking care of that right now. There were at least 2 consent agreements that did not incorporate the use of a filter team, but instead allowed the attorney for the owner of the devices to delete personal information before voluntary production to the FBI. These were the consent agreements that the department negotiated with Justin Cooper's attorney to obtain Cooper's personal laptops that the team hoped contained, among other things, backups from the BlackBerry devices used during the first 2 months of her tenure. According to the FD 302, I should explain, these are often referred to as 302s. The FD stands for Field Directive or Field Report. This is what the agents use to write down that part of the investigation, who they talked to, what they talked about. Again, in the parlance, they're known as 302s. I should have said that earlier. I apologize. According to the 302s from Cooper's September 2nd, 2015 interview, Cooper's attorney told the FBI that Cooper's laptops contained, quote, files related to the upgrade of former Secretary of State Hillary Clinton's BlackBerry, unquote, as well as emails Cooper exchanged with Clinton. In a letter dated September 10th, 2015, Cooper's attorneys wrote to Prosecutor 1, quote, as we discussed and as the government has agreed before providing Mr. Cooper's computer hardware to the FBI, we will remove and securely delete Mr. Cooper's personal and business files, unquote. In a letter dated September 24th, 2015, Cooper's attorneys wrote to Prosecutor 1 that he was voluntarily providing the FBI Cooper's MacBook Air laptop computer and further wrote, quote, as agreed, we have securely detailed from the MacBook Air Mr. Cooper's personal and business files, and we have overwritten its unallocated space with zeros. You're just giving people the opportunity to wipe away evidence. You're handing it to them. Is that unusual? It looks like that process is fairly common. We asked some FBI and department witnesses why they did not use a filter team instead of allowing Cooper to delete his personal files. FBI witnesses told us that they were not concerned by the limitations in the consent agreements for the Cooper laptops because Cooper was particularly cooperative and the materials he voluntarily provided to the FBI turned out to be fruitful. Indeed, according to the 302 from Cooper's interview, Cooper's attorney told the FBI about the backups on Cooper's laptop without prompting. In addition, FBI Attorney 1 and Agent 1 told us that they reviewed Cooper's devices to be different. They considered, Cooper's devices to be different from other devices they reviewed because there was no evidence that Cooper was the sender or the recipient of classified information, and Cooper was more of an aide to former President Clinton than to former Secretary Clinton. Strzok told us that the team was not certain that it could establish probable cause that there was classified information or other evidence of a crime on the Cooper laptops. Frustrating. Some FBI witnesses told us, consistent with text message exchanges between Strzok and Page, that the FBI was concerned that the line NSD prosecutors were intimated by the high-powered attorneys representing Clinton and her senior aides, and as a result, did not negotiate aggressively with them. Strzok told us that Prosecutor 1, who handled most of the negotiations with counsel, is, quote-unquote, extraordinarily competent, but he believed more senior government officials should have been involved with deciding, quote, how hard to push counsel, unquote. Nevertheless, the FBI witnesses generally told us that they were satisfied that the limitations of the consent agreements did not impair the investigation. Agent 2 stated regarding the limitations in consent agreements, quote, I think generally we were able to get what we were looking for. It maybe was more complicated, time-consuming, and cumbersome, unquote. The lead analyst told us every single consent arrangement constrained what we did to some degree. However, he, Strzok, and FBI Attorney 1 all told us that they believe the team might actually have obtained more through the consent agreements in some instances than they would have obtained through compulsory process. Strzok explained that for some devices, they were not certain that the team could establish sufficient probable cause to convince a judge to issue a search warrant or allow a search that was as broad as what was agreed upon through a consent agreement. He provided as an example the Cooper laptops described above. Similarly, Prosecutor 2 told us that the Midyear team was able to search certain items through consent agreements despite privilege issues that may have caused a subpoena or a search warrant to be quashed. I understand how they could have been between a rock and a hard place, but it's amazing how much latitude they gave the Clinton people in order to get away with wholesale deletion of what were at least possibly emails that had to do with this case. In addition, based on our review, we determined that Department and FBI members of the Midyear team worked together to determine the scope of the review of the evidence and, in turn, the limitations to be included in a consent agreement and search warrant. For example, in a September 23, 2015 email exchange among a WFO computer analyst and recovery team forensic examiner, CART examiner, Strzok, the lead analyst, the 4 line prosecutors, 3 FBI OCG attorneys, and 2 case agents, Prosecutor 2 wrote that she assumed the consent agreement for the PRN server would be scoped such that the FBI would not review the content of any emails in domains other than the clintonemail.com domain. Strzok wrote back with a more expansive approach that suggested by Prosecutor 2, quote, I think we should ask to search the other domains for any emails to from the @clintonemail.com domain in the event those emails were deleted from whichever clintonemail.com account and no longer available there. The final consent agreement followed Strzok's more expansive approach, allowing the FBI to search the entire server, including the unallocated space and domains other than the clintonemail.com domain for any emails to or from Clinton. I'm going to take a break at 7 o'clock Central Time in a few minutes, and we'll read through this next section, and then I'll stop. I think what I'm going to do is stop and restart the stream, so when YouTube compiles these videos to be run standalone, they won't take as long to process. You know, it'll cut up the process because this is going to take hours. And again, I said I was going to be here for the long haul. I'm not ducking my promise, but I think it would just be advantageous for YouTube and my channel for that, and also that allows me to put the banner back up about the live stream, and more people will have a chance to see it and come in. I hope that's okay. You know what? Let's just stop right here at section 5. It's almost 7 Central Time. I'll be back at 7:10 Central Time, and we'll get going. Okay, so we're stopping at page 88, section 5. I'll scroll up to the top. Okay, we'll be stopping there, and again, I'll see you all at 10 after 7 Central Time, so 13 minutes from now.